Okay, we are live. We have a quorum. We'll call the meeting to order. Do we have a motion to amend or adopt the agenda?
So moved.
Second.
All in favor?
Aye.
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 Okay. We have to approve the minutes from last week's meeting. I think, don't we? Yes, there they are. Does anybody want to take a look at them again? Hang on. It's very hard to see the little tiny writing, so hopefully everybody had a chance to look at the minutes.
Well, it's mainly just the policies that we forwarded. So
Yeah. Okay, so everybody, do we have a motion to approve the minutes?
so moved.
Second.
All in favor?
Aye.
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 Okay, so the next is the superintendent's report. May we have the report, Dr. Thomas?
Yes, ma'am. And I am very short today as we just met recently. So as you know, we're just attempting to ensure that all of our policies are up to date. And Dr. Myers and Mr. Pruitt were not aware. So we've learned a lesson in that about our norms work with GSBA. And so there were concerns wanting to ensure that our norms do not conflict with policy. So that has been a significant amount of conversation over the last couple of weeks. Dr. Myers has created a document to do some crosswalking of that. And so I'm going to just turn it over to her because that's all I had really for today.
Thanks, Dr. Thomas. Yes, I'll just share by email, or Dr. Thomas can. It's a Google Doc, and it's basically just the list that the board had come up with, I guess, during one of the governance trainings and it's called Other Norms to be Developed. And Ms. Tillman was very helpful to me. We scanned the policy manual, and really we've just inserted links to policies that might have something to do with those norms so that the board can, at the same time you're developing a norm, see what's existing in policy. It could lead to a number of things. It could lead to a policy revision. It could lead to a norm expanding and expounding upon the policy, but it's really just a point of reference, and I hope it'll be helpful to the board in their work of developing norms.
That's
Thank you
great.
for that.
That
Thank-
really, yeah, that is great. I know that came up and when we were trying to approve the last norm, there was some concern about its conflict with policy. So yeah, that's great. I don't think in the end it ended up conflicting, but we were able to augment it so that it was more consistent. So that's great. Thank you for that. Anything else then on that?
No.
Okay, moving to the chair report. The only thing I was going to talk about today is, again, formalizing our response to the Cognia report and choosing and prioritizing the policies that are most directly described and directed in that report. Dawn has created, again, another document for us to work with. The Excel file or the Google Doc, I guess I've got it downloaded as Excel, but there's tabs. The tabs listing all the policies, the last revised date, and I think we talked about last time, working through the oldest policies. Most of them are the 1983 policies, and we decided to start with the human resources because of the availability of Meredith. Thank you, Meredith. How much longer are you with us?
Well, hopefully forever, just minus 4 weeks during the summer.
Oh, okay. All right. So there's this month when you're not here. I see. Okay, great. So it's not a permanent disappearance. It's just a temporary. Okay.
No, ma'am, I'm 220, but if y'all need anything, I'm generally available and can be here. So don't worry about that at all.
Okay, that's great. So, well, for that reason that we started with the HR policies, and that's why we're doing G policies today. But I think in terms of the discussion and the recommendations from Dr. Myers and Dr. Thomas, I think we want to look at the specific, have a special meeting sometime between now and the next board meeting to have a discussion of some of the more directly mentioned policies. And Dawn, do you want to talk about that a little bit, or do you want me to try to talk about that in the report? I think you've highlighted BDA, CB, CEA, EGAG, and GCB. Is that what I am reading correctly?
It is. Those are ones that they specifically mentioned, but I would caution, they really just said this is a smattering, an example. I think they just pulled from the policy manual. I'm not sure I interpret, but I would be really interested in other people's interpretation of the Cognia report to say these are the most egregiously out of date, or these are the ones that need the most attention. They really just gave them as exemplars. So while
Okay.
I think those deserve attention before December, if nothing else, then they brought them to our attention.
Right.
I'm not certain it was a very specific directive to address them first or in any priority above other ones. So it's really how the policy committee would like to proceed in the work. I think there is an advantage going section by section, because when you're looking at, just like we did with B policies, when you're looking at G policies, you kind of get a sense and an understanding of that area of functioning of the district. And it's easier to make sure that policies do not conflict with each other at times when you're working within one policy section. But
Okay.
really, we can do it either way. We can certainly address those. We can pull from the dates that are in the 80s and then move to the 90s. It's just, if we did that, it's going to cross from student policies to finance policies.
Right. Right. Yeah, so there's a trade-off between kind of tackling them as a block and tackling them by date. I guess the only thing I would add, or that I wanted to add, is in addition to the ones on your list that you've highlighted, conversations with the board, and Dr. Gant, maybe you can join in here. We've talked about BA and we've talked about BBC and BC and how the board meetings operate, how we do our yearly training and sign off on our ethics, that those we definitely want to review those really soon and get those in order sooner rather than later. So that was my impression, at least from conversations with board members. So so I think what the cut to the chase is, I think we want to try to find another date between an extra meeting, if we can, to focus on some of these really high priority ones related to Cognia sometime before the next board meeting. So I would propose sometime, well, so we have our retreat next week. So about the charter thing. So maybe we should try to do it the week of the June 1st, 2nd, 3rd, or 4th before the next work session. Does that work for people? Or Dawn, what do you think?
So we need to allow sufficient time to allow Mr. Pruitt, as he did with this meeting, to really make sure that we're making good use of our policy committee discussion time by already having the policies vetted through the legal implications and all that. So we just need to allow enough time. Don't forget that June 4th date is a work session. So if we want to move quickly to have any policies that are approved through policy committee also arrive on that work session agenda to be voted on to go up for public comment the second week in June, we would just need to have, I know that one of the times you proposed, which I think scheduling wise makes sense, on the 4th, I'm not sure we could actually meet a couple hours before the work session and then also add them to the agenda. We'd need
We could not do that, right? We need a week in advance. Yeah. To give people time to
well,
look at.
no, well, here's the thing. We could amend the agenda, and probably Mr. Pruitt can confirm this. If we met from 4 to 6 ahead of a work session and we had lined up 5 policies that wanted to add, I mean, that's the purpose of a work session, is to set the agenda. We could always amend the work session agenda and say the policy committee just met. Can we consider these policies? Is that correct, Mr. Pruitt?
Sure.
You just would, the board just wouldn't see them in advance of the work session, but that's okay. They'd see them in advance of the next week's board meeting.
Oh, right.
Yeah,
Right.
remember, you don't even formally adopt the agenda at the work session anyway. That's just the administration for presenting that to the board. So,
And we could presumably, especially giving you heads up, Mr. Pruitt, have a list of the ones he was going to be reviewing that we might be addressing in that meeting.
yeah, so, I mean, what we, as I said before, what we discovered here is there are reasons to keep policies up to date because they get really complicated when they get old. So, I
Okay.
mean, attacking these the way we've done policy for the past few years is not going to make quick progress.
Right.
So,
By blocks, you mean?
I don't necessarily mean by blocks. I mean candidly, the length of discussion that we end up having about every policy.
Yep.
It's great to try to get things perfect, but with the timeline Cogni has put you on, I don't know that you have the luxury of letting the perfect be the enemy of the good as we go through these and try to do as much work as we can, and then maybe come back and do some fine polishing later.
Okay. Good point. So we need to pick up the glaring, contentious ones, the B policies that are causing problems, and then, like you said, do as quickly as we can through the old ones, which is going to be limited by your time and your ability to kind of check them out.
Yeah, it is. I mean, we may have to get a little better system for, whatever, like with this one with Meredith. If she and I had a little more time, maybe just to talk about this ahead of time,
Okay.
before any pens got put to paper, it
Okay.
might have gone a little faster. So
Well,
there's just a lot of unraveling here. These policies, they cross-reference. I was talking to Dawn about this. There's no set. We have these divided out, and we think that, all the G policies, Lynn and Meredith know everything there is in those. Well, no, they touch on areas of instruction and finance, and the same is true in the other areas. So,
okay. So what would you like? What would work better?
well, that's the question. So, what we have is a policy manual with hundreds of policies in it.
Right.
With language duplicated across separate policies and separate sections. Again, I believe a simpler manual with fewer policies would be more user-friendly and would show the kind of progress that we're trying to do between now and December.
So one of the things that was mentioned in one of my conversations with our GSBA people, Julie mentioned that one of the services that they provide is like a policy review, a full policy review. I want to say she said update. I don't know if that even fits here. I don't know if it cuts over into your, area, Mike, but we were talking about it shortly after the Cognia report. So she said that is something that GSBA could offer. They do it in collaboration with their attorneys. I'm just putting that out there. She also mentioned, though, that, the policy committee, as we have it operating, may not be the most conducive or it may like set up the perfect opportunity for overreach. She said there. Go ahead.
Sorry, about the GSBA, we did look into that pretty extensively when Dr. Sherry Freeman was my supervisor, maybe 3 years ago. We did, and I can pull out the emails back and forth. It's about, at that time, it was maybe $12,000 or $14,000. It's with a price to it. It's not for free. They don't offer that as a free service. It's a pay.
Yeah, no, she didn't suggest it was free.
Yeah, but what we found, and the reason that I recall, but I'll search my emails to make sure I'm saying this correctly. The reason we decided not to invest resources at that time is they don't make the actual recommendations to how your policy should be revised. They were going to policy manual and say, you need this one, you don't need this one, but they were not going to do the hard, tedious work is what we're doing. The highlights, the strike throughs, the crossing it with the other policies, making sense of it. They don't know our district. They don't know what we want the policies to say. It was a cursory look. Do you remember that, Mike? We got a lot of.
Yeah, I remember. Well, and I've been through this, and I think that's really something worth considering. I had been through that process with Muskogee County. I don't represent them, but one of my law partners does. And I worked with him as they went through that. So my recollection and impression was that it was a little more than that. I mean, so it's the same. So you get that policy alert every month where they rewrite a policy or two if there's been any change. So that's what you get. You basically get the off-the-shelf product of all of those policies in its most recent form since whenever it's been updated. And it's mostly just the policies that, you know, the law requires, or it's pretty obvious you got to have. So, you know, what you would have to commit to going into that process is that you are getting a fairly off-the-shelf product that can, you know, sort of reset your base, get you started from there, and then maybe start refining them and customizing them to yourself again. But, you know, if you get their I mean, they'll send them all to you in it seems like it came in maybe 2 or 3 packets, but you get them all pretty quickly, and they want you to review it and basically adopt them at the next meeting. So it is very different than this process where we spend a couple of hours talking about 3 policies.
Yeah.
And is
when
like 6 months or something, Mike, do you remember that? It was something, I'll find it and send it to the policy committee.
Okay.
There's information about how it works. There's a runway, like a 3 to 6 month runway, which might fit. Sorry, Dr. Gant.
Oh, I was just gonna say, it just seems that that it was relevant here. Part of my concern, Dawn, was actually the thing that you mentioned. On the one hand, it seemed like it would be like perfect, like, okay, we can just reset, we can like really get all of the noise, like the sort of fuzziness, and get down to like what's needed and sort of rebuild. The other part of that is that, you know, we as a board, I think as a community, and I think that this could be one of our strong areas of collaboration, you know, just depending, you know, and I think it does sort of take that piece out of it. And I also worry when she mentioned that, that it might get held up. You know what I mean? Like the fact that they give us something off the shelf, which would assume that we would read all of it so that we would know before the next meeting. But then it will also mean that all of us would need to be on the same page, or at least 5 of us. So anyway, but I just wanted to throw that out there, Tish, because it just seemed relevant for some reason. It just came back to my head.
Yeah, well, it certainly would be nice to streamline this process. Like Mr. Pruitt said, doing 3 or 4 a day or 3 or 4 every 2 weeks isn't really going to get us there. So I agree, if there is something we can do to streamline. And I'm not a lawyer, and I don't even have any legal background. I can read them, but I can't judge whether they're good, whether they're legal. So Mike, I guess it seems like we depend on your judgment of can you handle this by yourself, given enough time, or pulling in some help from GSBA. Sounds like it would help, at least on the big legal ones that don't need to be fine-tuned.
I think it's more what Lakeisha said. It's not necessarily the legal, you know, how much time the legal takes. It's how much time the board wants to take and the policy committee wants to take, you know, customizing this stuff. Again, if you just want to reset and get a set of basic off-the-shelf policies and then start over, you can do that pretty quickly with this process that GSBA has, and it's worth considering doing that. But what they don't do is they don't start with your policy manual. They start with their policy manual.
I see. Yeah.
You'll get their policies. If you want to customize them, that's going to be up to you. And if you get bogged down in a lot of customization of each one of them, you're right back where you started.
Yeah.
that makes me just a little bit nervous in the sense that, you know, we've got a pot on the stove and we've got ingredients, which is our current policies. And then if we just dump in another pot, you know, and begin to sort out what we want in the soup, what we don't want in the soup. I don't know. I mean, I don't know how to throw out an entire set of policies and replace them with a new set of policies, even on the
Yeah.
same topics. It makes me a little nervous.
Well, and I'm probably overstating the case, but what is valid, I think, is they don't start with your they start with what they have.
Yeah.
Then they review your manual, and they did, as I recall, in Muskogee. I mean, they tried, and they talked to some people, and they tried to pull in a few unique things, but the starting point is the basic, up-to-date manual that they recommend for all the systems in the state, not the one you have and trying to subtract from it.
Okay. Well, so it sounds like it's worth reaching out to Dawn, your connection, and maybe to Julie. I can talk to Julie and see what she can tell us about what it would look like or what she recommends. Does that seem like a good idea, and bring that to the next meeting?
Sure. I'll find it and forward it ahead of the next meeting.
Okay.
We actually got a quote from them. I mean, we went all the way through kind of talking through what it would look like.
Okay.
And had some dates. I mean, we explored it. Now that was a few years ago, so it might be a little different, but I'll ask for the same kind of work plan proposal of what they can do. Yeah, here, this was in 2017, we last considered it. They have a GSBA policy services brochure. It was the steps that Harbin, Hartley, and Hawkins follows when reviewing policy manuals for GSBA. They're the ones that actually do the work.
Yeah, and they actually have, it's not really the lawyers there. They have one or two people on staff who do nothing but this policy work through GSBA for school systems around the state. So, I mean, it's
Okay. We might be able to
not
get
just
some
lawyer stuff. It's just real educational policy.
Yeah, maybe we can get a hybrid of sort of the plug and play versus personal attention.
Don, can I ask one question before we move on? We have, our policies are divided up into 12 sections. I mean, is it something that we could take one section and I'm asking you this, Mike, too. Can we, let's say, students, J, that we just kind of like look at what the state has as J policies compared to ours and just do it in chunks like that? I mean, to kind of, to see if it even would make sense to us.
So, well, there's no, so to get what the quote state has, there is no like government open state policies. What the state has is this proprietary set that GSBA does through the policy people at Harbin Hartley. So,
Okay. So you can't get it without them. Yeah.
But you can't, I mean, but it's divided up in the same chunks as we've got, right? I mean, they have general, I mean, we have 12 A through M. Does that?
yeah, ours comes from the GSBA taxonomy, which comes from the NSBA taxonomy.
Okay.
Here it is. I just found it on their website. It costs, I was close. It costs $12,500. I'll send this to the policy committee. It looks like there are options 1 and 2. We'll check your policy manual for policies listed in your chart of required policies, and you'll receive notification of any policies that need revising. Receive notifications of what changes need to be made to bring your policy manual up to date. And then there's a second price. In addition to the analysis listed in option 1, GSBA will review the content of any policies that have been added since we completed your manual revision. We'll make recommendations. So it's really an ongoing service that sounds like some school systems
Right.
them over and over to keep the manual updated.
Mm-hmm.
So certainly something to consider. Let me send the information so everyone can digest it, and then it might be we can add that to a topic for discussion for next time.
Okay.
And rule, it would be good to rule it in or out as an option going forward for the next 6 months.
Right.
Consider it. I think it's definitely worth considering.
Right. Because if it's ruled out, which is fine too, I think we'll definitely, I think Tish, as you were alluding to, have to have sort of a streamline or figure out a system over the next 6 months. Be it, of course, I think we should prioritize any of the low-hanging policies that were even implicated in the report. But then certainly that very first directive is review and update your policy. So we'll have to figure out a more efficient way,
Yeah.
to do that.
Let me have a chat with Julie if that's okay, and I'll put my head to it and see if maybe Mr. Pruitt, you and I could talk a little bit at some
Sure.
point and see if we can come up with a model to present to the next meeting. Dawn,
Yep.
talk, maybe put our heads together and see what the best approach is. Okay, on that note, maybe we should move forward to the 7 that we managed to talk about. We'll try, and keeping in mind, I have 2 pages of notes on the first one. Maybe I will try to hold my tongue just a little bit and see. So the first one is, let me pull it up, sorry. I've got too many windows
GAEA.
open. Yeah, so it's GAEA, which is about staff protection. And the original recommendation was just to review and no changes, but then Mr. Pruitt made some comments about perhaps deleting the last paragraph because it's redundant with EG, and that the second to last paragraph is also kind of unnecessary. So do we want to look at it? Well, at the moment, it's just reviewed and we leave it alone. How strongly do you feel about those redundancies, Mr. Pruitt?
Well, let's see, let me pull my
Given what you
policy
just
memo
said.
back up. So let's see. I mean,
If I
I'm not
recall,
too worried about I guess it's not illegal to have redundancy. I do worry about that next to last paragraph. That implies that we're doing things that we don't do and shouldn't do.
Okay. So I guess my read of it, just coming at it fresh, was it talks about threats, first of all, what we do when we get a threat, or when a staff member gets a threat, you notify, and then the notification, whoever's notified needs to do something, which I like. That's the first one. Then there's the effect of a student assault or battery, so actual assault affecting the staff member, and then that goes straight to the immediate supervisor with a copy to the superintendent and then ultimately to the board. So that's when there's a student who assaults a staff member. Then the third one seems to talk more about an adult or either another staff member or someone who's not a staff member, who's not a student, assaulting the staff. Can we combine those in any way, or do we really want to keep this? Because another adult would be referred to the police, I presume, whereas if it's a student, it doesn't get referred to the police. Is that the difference between those 2 paragraphs?
Ian.
It may or may not. It's definitely going to be, it's going to be reflected in student discipline, which is what Meredith's just going to say. So there's not a student that assaults a teacher. I mean, in fact, in the code of conduct that you just approved a couple weeks ago, the state has acknowledged that battery was not sufficient to describe a student assaulting a teacher. And so they've added a whole separate category in the code of student conduct for the state reportable infractions that includes assault on a teacher.
Right.
So it would definitely be reflected in that way, and possibly to the police as well, depending.
So do we want to just refer to the code of conduct in this policy? Meredith is nodding.
I think that's great for the student piece. We do have the rest of it dealt with through our normal processes because there's pretty strict code as to what happens if a teacher is assaulted by a student, if they need time off from work, if they have to seek medical attention, that's all handled through our workers' comp process. And so I do think I was going to say exactly what Dawn said, that that's really dealt with through our code of conduct. And you're right. If it's not a student, then it's either an adult on campus for some other reason, or perhaps a parent or something of that nature.
Right.
Hopefully not a coworker, but it could be, many other avenues. But I do believe the student one is best dealt with through the code of conduct.
Dawn, does our code of conduct, I think it does, it talks about reporting to juvenile or the DA, depending on, the type of offense and the age of the student. I mean, that's also within the code of conduct, right?
Well, it doesn't provide exact specificity around that. There's a whole page that talks about the role of law enforcement in schools, and it really is a decision that's made. I mean, a 6-year-old hitting a teacher is going to have a different outcome than a 17-year-old hitting a teacher.
Right, and a 17-year-old hitting a teacher could be a designated felony that takes them out of juvenile court to superior court. So that's why I say, I mean, it's like a lot of these policies, it's kind of it's trying to be half pregnant. I mean, I don't know that what we are saying here is of much use at all. The reality is very complex, and you could never put it in policy. It's a judgment call made on a case-by-case basis, at least as far as the criminal system.
Okay, so how do we, so what I heard from Meredith is that we can refer to the workman's comp policy in this policy, maybe? Or,
I was making sure I wasn't muted, sorry.
okay,
Actually not a policy, it's a code that addresses how you deal with, Mike, help me out. There's an exact reg. Remember, we've looked at this. If a teacher is assaulted by a student and they have to take time away from work, or if any injury, not even just assault, is caused by a student, then they're not charged that time. And then eventually workers' comp kicks in, and it's just all through the process and handled really without the need of a policy to direct it. So if you're looking to kind of simplify policies, that might be an easy way to do that. The process for an employee who is injured by a student is very well defined through our workers' comp processes.
so does it involve filing? I'm sorry, go ahead.
I don't think it's directly a policy, but it's a process that's guided by state. Might give me the word statute, law, reg.
Well, so there are statutes that are passed by the General Assembly. Regulations are promulgated by state agencies, and they both have the force of law.
Okay, so can you tell me, Meredith, if a teacher is hurt by a student in any way, what's their first step for the workman's comp?
If a teacher is hurt at all at work, regardless of how they're hurt, the first step is to they fill out an incident report, or their supervisor helps them fill out an incident report if they're unable to. In the case of a teacher, it's going to be their principal, their AP. It could be an instructional coach. There's someone at each school, usually it's the front office person, who's designated to make sure that report gets quickly to HR. If they need to seek medical attention beyond that, they're sent off. There's a panel of physicians that everybody's required to have.
Right.
And they're sent to a panel physician for medical treatment. A report is filed with our workers' comp carrier, and we'll authorize the medical care as needed. There is a waiting period before workers' comp may kick in.
Yeah, so I know, once it gets to workman's comp, I know it's complicated and yeah, because I've had that myself. So, but what we want to have here is what's the immediate first step? And right now it says you file a complaint with your supervisor, and then the superintendent and the board are notified. So is that incorrect as stands, or do we want to add a word about workman's comp, or do we want to?
So it's really an incident report rather than a complaint.
All right.
Better word for it. It's an incident report is what the form says.
Okay.
Perhaps that would be a little clarity. And then again, whether it went way up the chain, because a victim of assault or battery by a student, again, if a 5-year-old child hits a teacher, it leaves a small red mark, that may not require the same level of notification as if, say, a 17-year-old child caused a teacher to be taken to the hospital.
Well, and I think this policy is talking about crimes, not just injuries, you know, by using the words assault or battery. So,
Right.
I mean, we might have a special education student with profound issues who injures a teacher pretty severely, but that still does not have the mens rea and other elements that are necessary for the criminal offense of assault and battery. You know, an 18-year-old football player might punch a teacher in the face and have less injury than the special education student caused, but that is an assault and battery.
That's right. And if something arose to the level of where there was a crime committed, that's exactly what would happen. It would be forwarded up to the superintendent, who would notify the board if something rose to the criminal level.
So what would we lose if we eliminated this policy? I guess that's my question.
I don't think we would lose anything, because all of this stuff is things that are going to happen automatically for other reasons and other policies. I don't think that you're losing anything. It's just my 2 cents worth.
I agree.
And if you look at the date when this policy was written, I think this is it's a history lesson. What was the world like in 1987? Where was all of our focus? Let's get tough on crime. Let's make sure people feel protected. And it was, I don't know, I think it's really contextualized by the decade in which the wording was written. And that could very well be a holdover from what felt like the most important thing to put in policy in 1987.
And didn't we have a state law that was passed in the early part of this century that allowed teachers to actually have students permanently removed because they felt threatened? I mean,
Yes, sir.
Okay.
That's exactly right. And that's in my memo. That's OCGA 20-2- I think it's 736 and 7 or 7 and 8.
I believe it's referenced in the code of conduct. It's
right.
the policies that are in the code of conduct.
Okay, so again, I'm a little uncomfortable about just like deleting this whole thing and not putting in something that shows that the board believes that staff should be protected. So can we leave the first sentence, and then in terms of like refer to the code of conduct if a student is involved, and refer to workman's comp. I mean, I don't know how, yeah, I'm new at this still. So I just want to make sure we have a policy statement that says we support the teachers and staff, and we want to protect them in a way that is consistent with policy. So I don't want to just delete it if we can help it. Is that fair? I agree with the whole thing that you're saying about 1987, and I agree that it seems like some of this is redundant. So
I think it depends on, I don't know, I guess I can see both ways, but if in fact, I think Meredith and Mike and Dawn, what I hear you saying is that there are other things that are going to be sure that we're not saying that, teachers and staff are overlooked. So it's not something that we're not addressing, it's just addressed somewhere else. We're
Right.
not,
I was saying, yes, ma'am. I think that, in streamlining some of these, and when we recommend rescinding them, it's not that we don't care about the teachers and we don't want to protect them. It's just that it's done through another way. And so you possibly, one of the things that could help you guys as you get through some of the policies is to not have quite so many redundant policies. And so that was kind of where Mike and I were both at, is that this is accomplished without the GAEA policy, which is not required for us to have. And so I don't think you're going to lose the teachers being protected from abuse factor if you choose to lose this policy.
how would you think the teachers are going to feel if we just delete this policy? without using the opportunity to point to the other things that are their safety nets.
To answer from an employee point of view, I would never have thought that my workplace had to have a policy that said that if I'm the victim of a crime, that I have the right to be protected from it, because the law says that. And as a citizen, I can do that, and that the workplace has to provide safe environments. And so I would not expect as a normal citizen for there to be a policy that says you have the right to be safe at work, because there's a law that says I have the right to be safe anywhere. And so as an employee, it wouldn't, but I'm looking at it through an HR lens. So you guys have a different lens, and everybody has a different way that they see things. But I wouldn't feel that if we were in a streamlined process and we were trying to get things up to date, that it would send a negative message to streamline our policies, as long as we didn't do something dangerous to a teacher, or, something detrimental to a teacher.
Oh, it's in the student code of conduct, Dr. Meyer. I agree with Ms. Paget, but I disagree with Ms. Paget. I know that made a lot of sense. So I agree that we're in the normal assumption is that every individual has the right to be protected. I do think sometimes the feeling, though, is that when it is harm from a child, that people may not feel that they receive that same level of protection, or that people take that as seriously than if their supervisor slapped them or their colleagues slapped them. I do think, just having been in the building, sometimes I think people have a different tolerance level when it comes to students. And there are some people who really do feel that they need to be guaranteed that if anything happens to them from a student, that they are protected, and they don't want to feel that their supervisor would say, well, that's part of their IEP, right? Or, that's where some, I think, of this push the rub comes with that, because for some might be able to say, well, that's what you should expect when you're working with students who have some form of disability. Or so I can see how what Dr. Yeager is saying, that for some teachers, they want that definitive. Now, I'm not saying that that has to be here, having that in the code of conduct, or if we had a employee handbook or somewhere else that it could be. But I think some people really like that definitive, they can't hurt me kind of statement.
Does it make any difference as to what actually happens when an incident occurs? We had that happen not too long ago. We had a teacher hurt pretty badly by a special education student. Her page lawyer demanded that we go to the magistrate and get a warrant against this child who clearly didn't have the intellectual ability to form mens rea for a crime. We didn't do it. We're not going to do it. I would hope not.
Right.
And that situation would be covered in our code of conduct, or not really? Dawn, you're shaking your head.
Federal law.
And this is a student who's totally nonverbal and has a 40 IQ and injured someone who, I don't know what the code of conduct is going to do.
Right. Okay.
Yeah.
All right. So what if we reduce this to a simple statement that teachers and staff have the right to feel safe at work? And in the event that they're not, they have the right to talk to their supervisors, or I don't know, what do we want to, so do we just want to have that simple sentence there and then leave it?
Let's take the first two sentences, the first two paragraphs, and then add a third and say, if the employee is a victim of assault or battery by a student, it'll be handled administratively and per the code of conduct, and possibly with the involvement of the school. Is that too vague with the school police? And then if it's, because I think there is this equal question of staff protection from, and we've had this, we bar adults from schools who have come into our schools and aggressively, verbally or physically, seek harm on an adult. And we could say, make some reference to it is it is part of the function of our police force to maintain school safety and address issues when they arise. I mean, we have filed charges on adults who have verbally or physically assaulted our staff in our buildings.
Remembering that file charges is TV talk.
I know. Well, you made a report to the local authorities. How about that?
Exactly. Report it to law enforcement. That's all you can do unless you want
Report to
to.
law enforcement, right? Yeah, okay, so I'm hearing, leave the first sentence, maybe add a sentence that I just said, teachers and staff have the right to feel safe at work. Is that too vague? And then any employee who is threatened with harm is to notify. So that one was fine, right? Steps are taken at once to protect the employee. If you're threatened, right? That's fair. And then the last 3 paragraphs, we want to kind of combine into a single statement about the ability to file charges through the district police or the city police. How do we want to do that? I mean, so that's what we want to do, is collapse those 3 sentences when there's an adult involved.
So there's still the process, right? So there's still the process that the district is saying that the process for a teacher or an employee who's a victim, they should start with filing the complaint with the supervisor, and then it should be forwarded to the superintendent, right?
Yeah, okay. So
That's
leave that one alone.
If that's still the expected process, it seems that, you know, I guess, I don't know, I'm asking from Dawn and Mike and Zernona and maybe Meredith, like, what is this, you know, the process that we would expect a person to go through if this were the case within the organization? Like, we know legally what a person can do outside of this maybe, but within, you know, the school district.
I think she said that if the injury is caused, that would be an incident report,
Okay.
not a complaint. So we should at least change complaint to injury report.
Well, again, I think this uses the word complaint because they're assuming it's a criminal activity.
I see.
So,
What
I
about,
mean, you know, we have tons of workers' comp stuff. I mean, it's not beyond what's in the policy manual. Everybody knows that if you get injured, you're supposed to do the incident report. Even if you don't think it's important today, do it anyway, no matter who causes the injury. For purposes of this, I mean, the common sense is, of course, we want everybody to report to their supervisor if a kid has been this dangerous, so it can be dealt with. Whether,
Okay.
you know, you report, whether you go through, you probably go through the social workers if you want to make a report to juvenile court. And one thing, Lakeisha sort of alluded to this, and even if all the staff of the school district end up telling that teacher, we don't think this needs to go through the criminal legal system, juvenile or superior court. You know, any citizen that teacher can still go make her own report to the police.
They do.
so what if we have this, the first 2 sentences leave alone, and then we say something about if a student is involved in a safety situation with a teacher, we follow the code of conduct, and if an injury is involved, we follow the workman's comp rules, and if an external adult is involved, then we work through the police or something along those lines. So you just kind of,
Sometimes we work through the police if it's a student, if it's an, you know,
Okay.
17 or 18-year-old who commits a
okay,
violent offense.
Can I just say that I think that second sentence that you're talking about, where it says notify the principal, steps are taken at once to protect the employees. If you leave that sentence there, what that then allows you to do, if you don't kind of maybe go into a lot more detail beyond that, is take the appropriate steps based on the scenario. So the first 2 sentences would stay, and then that would allow us, instead of policy-wise, to procedurally wise cover the next set of steps, be it an instant report for workers' comp, or notifying ACCPD or a social worker, or whatever the situation would be, we may not have to actually directly address the policy. Just say that notify your principal immediately, and so that the proper steps can be taken, and then it can be dealt with situationally, because everything is so different. Mike's right.
Okay.
Sometimes it goes in a million different directions, but maybe this would do what you said, is make sure the employees feel supported and protected, and that we will immediately take steps to protect them from whatever the source of the harm is.
I
Okay,
agree
so-
with Meredith. I think the first two sentences, because also the first sentence references psychological abuse, and that's going to be a big one. When a child says, I'm going to bring my gun and shoot you in your head, you know, we don't really want to have such specificity of what exactly is going to happen, or does that mean charges are filed? But Angela, can you add I like the sentence, and I captured it on my paper, that Dr. Yeager said, add to the end of the first sentence, the second sentence that says, teachers and staff have a right to feel safe at work. The very affirmative statement. If we leave that, and then we leave that next sentence as is, taken, the next steps are to be taken, and then end it right there. Is that what you're suggesting, Meredith?
Yes, that's what I was saying, is that I felt like what's happening afterwards is we're trying to address each type of thing
Okay,
that
fair enough.
really already addressed procedurally. Like you said, there's a lot of workers' comp regs, there's a lot of legal stuff, but at least we give them this policy that says we're going to protect you at work, and we will take the appropriate steps regardless of how the threat or assault or whatever it would be is presenting itself.
Okay, so Angela, are you editing right now? I would say teachers and staff have the right to feel safe at work should be first and foremost. Put that first, and then say the school district will be vigorous in its protection of all employees from physical and/or psychological abuse. And then any employee who is threatened with harm or harmed. So we shouldn't. So the first that's or harmed or threatened with harm, or however it goes, is to notify his or her principal or supervisor immediately, and steps are to be taken at once to protect employee safety, health and safety, maybe.
I have a question for later, Mike, maybe to put on Mike and Dawn's radar, because I think this just may be a matter of me not fully knowing how all other policies speak to this. But when it says, when it alludes to the physical, or it states physical and psychological abuse, and this, as an employee, I would notify my principal or supervisor immediately. What happens in the case where the principal or supervisor is the person causing the harm, or is that a totally different, and we don't have to discuss it now, but I'm assuming that may be addressed somewhere else.
That's addressed through the policy, where people have the right. There's a separate HR policy that talks about employees having the right to bypass their supervisor and go straight to HR if they feel
Perfect. Okay.
That's completely addressed in policy. Actually, it's the harassment, and
I was going to say, we have 3 or 4 pages and pages of HR, a policy on harassment, which is interesting. Yeah. So
Thank you.
do you want to add a noun in there somewhere to say notify his or her principal or supervisor or HR? So any employee who is threatened with harm or harmed is to notify his or her principal, comma, supervisor, comma, or HR immediately? Or do you want to not make it? Is that too much? You already have it somewhere else.
I do think we already addressed it somewhere else, but I don't see a harm in putting it in if you feel it's important here. Whichever way you feel would be okay. We do address in a couple of different places that there is a path straight to HR, but if you feel it's important here, I think that's fine as well.
GAEB, Meredith.
Thank you. Actually, GAA, I think also, and GAE both reference it as well. Talk about getting to HR for complaints and issues with your supervisor.
Okay. Well, I'm happy to have it in here if that's okay, but Okay. Well, we just broke our rule, but I
Yeah,
think,
I was gonna ask, do you think it's gonna be a problem that I didn't get to all of those policies in the memo?
I think this was the worst one, was my feeling, but so are there any more discussion on this particular one? Should we move on to the next?
I guess I just have one. Can you scroll to the bottom of it just a second? I'm just wondering, Mike, see how we're citing all these state rules and laws? Is that something, you know, for further reading? Is that something that, to me, it's more confusing than it is helpful? And I just don't. Is it something that we need to do?
So let me tell you where it comes from. When you use the GSBA platform for your policy manual, which we did up until a couple of years ago, that we never wrote that. GSBA wrote that. Same people who would do your policy manual if you hired them to update it. So if you use the GSBA platform, as the laws change, that'll change. What we did is just copy and paste what existed at the time we quit using GSBA and put it into board docs. So some of this stuff is already obsolete, and that's just going to get worse the longer this goes on.
So I guess I'm saying, like, for instance, the law that we cited about if a teacher feels threatened with a student in the classroom, that's not even cited in there. And I just don't, and these others have nothing to do with the topic.
Well, they don't, because those are the closest things that GSBA had under the heading staff protection. Now that statute is, if you go to policy EG, you'll
Right.
see it there.
Okay. I'm just wondering if do we need to put this down? I mean, is this something that, this is lawyer speak, and I'm not sure if it helps anything.
Well, I got to tell you, if it were up to date, it's really helpful to me because it tells me, you know, it's the shortcut to find the relevant statutes to compare to what we're working with.
It's not up to date.
But it's not up to date. I mean, it's still okay for now. 10 years from now, it's going to be totally worthless. Unless we go back to the GSBA platform instead of board docs, in which case it will be up to date.
But what does search and seizures, sick leave, and fraud and waste have to do with what we just altered?
Well, as of 17, 18, when we quit using GSBA, if we knew what their staff protection off the shelf policy said, those statutes might relate to what theirs said, but doesn't relate to what we have in here from 1987.
Okay.
I think the reference to the sick leave for teachers references back to the, if it's a workers' comp injury caused by a student, they don't have to use their sick leave, which again is covered in workers' comp and not in this policy.
Okay. So are you saying we can't take it out, or we shouldn't take it out? I guess
We made a decision when we moved to board docs, and we migrated all of our policies over to just grab those legal references while we had them from Symboli. But Mike's exactly right. They're not being kept up to date, but they provide some context, at least in the moment. And the decision was made when Dr. Maines asked to keep those references in when we migrated to board docs. That's all.
Yeah, I mean, if you think they're confusing for the public, and I mean, certainly there's no law that requires them be in here. I'd ask that you make me a paper printout of it before you delete it, so I'll still have the references.
okay.
I would say, I think maybe we should leave them in right now, because we're still trying to figure out, number one, what we're going to do with policy. If we're going to go the GSBA route, we're trying to figure, there's a lot of transition going on right now with just the historical knowledge that we will have at the table. And, you know, eventually, if we ever go back to that platform, is it Assembly? I don't know. I just think, like, if this is an area that's not our expertise and law is not our expertise, and if it provides some type of context, even if it's not updated, or it gives our attorney a starting place, then I think right now, I don't see any harm. The harm is that it's confusing, but I don't think it takes away from the policy.
Ms. Linda, did you have a comment?
Yes, thank you. I had a question. So when we get those notices from GSBA every month where they talk about policies, and they're talking about their policies that need to be updated, but we also, do we not get notices about code that's changed? Remember in the past. Go ahead,
I'm
Mike.
sorry, Linda.
I was saying that I remember in the past in policy, we started our meetings with, these are the things that have changed. And so these are the policies where we need to make the change. And we simply updated those policies to reflect the changes that came down through the, through GSBA's path, I guess, or through the law. So if these references are outdated, I don't understand how they got to be obsolete and outdated if we're still getting those notices and doing maintenance on the policy manual.
Because we're not updating that part down at the bottom. So if so, as I said, those monthly policy alerts from GSBA are put out by the same people who maintain the GSBA assembly platform.
Right.
So what, if you were using GSBA for everything, then you get the policy alert that tells you need to amend the text of your policy. The legal references down at the bottom would have been updated automatically for you.
Right. That's
So
the
we have
benefit
not
of using Symbol.
updating policy. I'm sorry. There was a time that we updated our policies based on those notices, whether they were in board docs or assembly or wherever. So are we saying we don't do those updates anymore?
No, we do, Ms. Davis. That's exactly what guides our policy agenda creation.
Yeah. Okay.
That's part of how we revise our policies. Part of it is the board said 3 years ago, we want to tackle the B policies and we really want to get a handle on board governance. But inserted in those meetings, if you look back over the last 3 years, are certainly recommendations of policies that needed to be changed on recommendation of the GSBA policy alert. It's a service that they provide. We still subscribe to that service. We pay for that service still to get those alerts. It's much less. I think it's $2,500. We kept, when we let go of Symbly, we made an intentional decision to keep the GSBA alerts because it's a good use of their resources to remind all the school districts in the state, hey, the Georgia legislature changed this. You might want to look at your policy. We absolutely have been doing that work.
Okay, that makes me feel a lot better. I started to get nervous. We're saying in 10 years, it's going to be all obsolete. I just don't want us to stop doing that maintenance, that level of maintenance.
No, what I was talking about is only the legal references down at the bottom.
Okay.
So if we update, if we do what the policy alerts tell us every month, our text will have been updated, but the policy alerts don't give us the language to update the illegal sites.
Yeah, so then that's kind of the other question. I know that we pay attention to House and Senate bills and things that passed, but now we're not taking that legislation and running through our policy manual, are we? Or are we doing that?
No.
Well, that's why we subscribe to policy alerts. They do that for us.
Okay, I'm good. Thank you.
Since we don't since we don't subscribe to Assembly, we aren't getting it automated, the automated updates.
But there was a law that was passed 15 years ago that dealt directly with this topic, and we're not citing it. So it's an EG. It's because it was an EG. So policy alert that month would have told back 15 years ago, would have told you, you need to adopt a policy EG, and here's what it should say.
Any other comments on this one? I'm noting the time. It's 5:23. We have several left to get through. Shall we tackle the GCB, which is also just a review? No changes?
Shall we make a motion to
Oh, sorry.
this one forward, Dr. Yeager?
Thank you. Sorry. Do I have a motion to move this one forward as amended?
Yes. So move.
Second.
All in favor? Aye.
Aye.
Thank you. Okay, thanks, Dawn. So GCB is a review. Mike's comments was there are no impacts of the charter system. There are no, this is not required by law, although this policy does comply with law and probably is necessary for retention.
And the reason I said probably is necessary is because, I mean, it does come up from time to time, you know, how do you create a new policy position? I think it's useful to have administration and board on the same page that here's how that happens.
Yeah, okay.
And I do want to point out that we have been in violation of this policy in the past. So I think it's good to have it there.
Greg's saying explicitly what I was implying.
Okay, so do we have a motion to move this forward as is? Or do
So-
we, other comments? Dr. Gant?
Yes. No comments, but yes, move forward.
Okay, all in favor of moving this one forward without revision?
Aye.
Aye.
Okay, so moved. All right, moving on to policy GAK. So GAK is the personnel records policy. So I was confused. There's GAK, Dawn, and GAK parentheses 1. And this is not reg, because that's reg 1, which is down below. So we put numbers after GAK in parentheses. If we delete
anymore.
GAK, not anymore. Okay.
Used to, and we haven't cleaned it up far enough to get rid of that. So at some point, well, for a while, here's one story that everyone needs to know is that if you're with Symboli under GSBA, and this is one of the things that Dr. Means didn't like when we were revising the B policies and recommended to move to board docs, you can't make up your own policies. You have to go with their schedule of what are the letters that precede a policy. It's pretty formulaic. You can, anyways. So, at some point, I think to get around that perhaps is my only, it was before my time, so I don't know the history on it. Instead of making a new policy, we would use the same set of letters and put a 1, and it would be, that indicates a separate policy. And sometimes they're about very different things. And,
Yeah.
this is one of them. GAK is called personnel records and GAK1 is criminal background check. I don't know. I don't have the history on that why, but that's exactly what it is. Those are 2 different policies, not regs. So I think in the cleanup, in the big cleanup of the policy manual, we should do away with that because it's confusing and it makes no sense.
Well, but wait a minute, let's go back to what Dr. Gant just said. We're still in this flux. We don't know if we might go back to the GSBA platform, which if we do, that's their, you know, they do the letters and the titles of the policies. And if we hire them to do the update, they'll at least give us a pretty good guide of what the content should be as well.
Do we think they have a GAK1 that's called, maybe they do, criminal
Oh,
background?
yeah, absolutely.
No, these are the GSBA numbers and they're very, very different if you look at them. That's the one we're recommending to rescind and the other one is just a review.
Right, they are very different. Yeah, so, okay, so, so we can rescind GAK without rescinding all GAKs associated with it? Okay, so
They're
GAK1,
not associated.
they're not associated. Okay.
Anything in front of the dash, consider it a standalone. So GAK and GAK parentheses 1 are 2 completely separate things. So we can rescind GAK and not rescind GAK parentheses 1.
Okay. That's very confusing, like you said, Dawn. But okay, so at the moment, so we're talking about GAK. GAK currently just says something about the Open Records Act, which is almost perfectly verbatim in the other policy. So the point is to delete this one altogether. I guess the question in my mind is, does GSBA have other pieces of like how personnel records are handled and confidentiality that we don't have in here that would be in there. So I guess that's the conversation we have next week, is whether there's GSBA policies that we want to include that we don't have. I mean, like personnel records and then just going straight to an Open Records Act seems like it's been abbreviated or shortened somehow.
Well, let's see, back again, when we stopped using Assembly just a couple of years ago, the legal references were for the clearance certificates, but that's what GAK1 is about. Duties of superintendents, fundings, annual contract. And 501872 is just back to the Open Records Act. So it doesn't appear to me that there's anything in there that's you need to put in policy.
Okay. All right. So anyone have any issues with just rescinding this one altogether as shown?
So moved.
Second.
Okay, all in favor? We have a motion to move this forward and rescind?
Aye.
Aye. Okay. 5:30. All right. We have a policy and a reg on criminal background checks. And it's my view that there was quite a bit of overlap between the two of them, which seems sort of odd, since I know the one is sort of the policy that we have a criminal background check and when it should be applied. And then the second one was more about how it actually occurs and who pays for it. Is that right? So this one, to be eligible for full or part-time employment, an applicant must first submit to fingerprinting and a criminal background check. Can we just end that sentence, period? Or which will be conducted, I mean, because is it always conducted through the Clarke County School District Police Department? Yes.
Well, I think that's in there, Dr. Yeager, because sometimes people show up and say, hey, I'm doing this work at UGA also, and they just ran my background check. Can you use this one? And so we've really tried to have it be vetted only through our police department. And so I think that's the purpose for that.
Okay. What about the next sentence or two? Because those details are in the reg. Did we freeze, or are you just looking at it? So.
But I was thinking, I thought I had dropped the call.
Oh, okay. It's very quiet. So, I mean, the cost of fingerprinting shall be borne by the applicant, and the part about the 20 days are both in the reg, or at least they were. They're the first two sentences of the reg.
Did we lose Meredith maybe? Oh,
I'm reading the reg. I'm here.
Okay.
I've only got a laptop and then a very tiny device, and my eyes are about 42, and that's just giving me a pause for just 1 second.
Okay, I'll be patient.
That's going to get better in a few years, Meredith.
Thanks, Mike. I'll remind you. Okay, the regs. Oh, gosh, this is just not loving me. I'm so sorry. My device is not cooperating.
Okay, well, the first line of the reg, I can read it to you. All personnel employed by the Clarke County School District shall be fingerprinted and have a criminal record check performed, which is identical to the policy. But then it says the district may employ such person for a maximum of 20 days in order to allow for the receipt of the results of the criminal record check. Which is basically what it says.
Right.
Second line of the policy, which says something complicated, notwithstanding the foregoing eligibility requirements, the school district may employ personnel for a maximum of 20 days in order to allow for the receipt of the results of the criminal background check. So there's redundancy, I believe. And generally, I understood that sort of the details, like the 20 days and the who pays for it, should be in the reg. But Dawn, you're welcome to correct me because I'm brand new at this.
No, you're right. The reg is how you do it. The policy is what you do. The reg is how you do it in the details. It's okay that there's some redundancy. If we want to shorten the policy manual, we should figure out which goes in the policy and which goes in the reg. That's perfectly fine, as long as it's in one or the other. And
Okay,
effort should be made. Policies, a lot of times, are 1 or 2 or 3 sentences. They're more,
yeah,
they're more aligned to the very first one we just discussed and revised, where it's the aspiration.
it's the aspiration, yeah, it's the idea, what we want to have happen, yeah. Okay, so Angela, for this one, I think, pending other people's comments, I think we would delete from there, costs.
Does it say the cost in the reg? I'm trying to find that, Dr. Yeager. Help.
We took that out because it changes so frequently, Meredith. When we revised this last in 2018, the reg, we took out the specific cost because it can change in an instant, and then our reg was out of date.
So the reg currently says, Meredith, for fingerprinting of new employees in permanent positions, the initial cost will be deducted from the employee's first paycheck to pay for the record check. If requested, the fee can be divided between the first 2 paychecks. And then it
Perfect.
says
You
for all other new employees must submit a money order at the time of fingerprinting.
And Mr.
Perfect.
Davis will remember that. He was on the policy committee then. That was an effort to not have our lowest paid employees have the majority of their first paycheck be paying us back for their fingerprinting. So that was a change that was made very recently in 2018. It used to say in the reg, it cost $42.50. And every time the cost changed, our reg was out of date. So we removed that specificity, which is not necessary, but we added some effort to not make it a hardship on lower paid employees.
Okay, and then the rest of the policy talks about criminal background checks that happen periodically with employees, which I think looked totally fine, right?
Mm-hmm.
And then handling criminal record information, I think that sentence is fine because it talks about authorized purposes only, da-da-da-da-da. So
Mm-hmm.
seems like that one is in pretty good shape as long as we sort of get rid of the extra redundancy.
Mm-hmm.
Other comments, questions?
I just had a question. How do we do substitutes? Who pays for them?
That's through our contract with ESS. They still pay for them. I believe ESS requires them to pay for them. We're not paying for them, but their background check is actually still run through us, because if someone fails a background check for some reason, I still am the one who, Lynn or I, want to review each one of them. It's not a pass. And so will Chief Stevens, because there's things saying that you have to look at them case by case. Or Chief Stevens, I'm so sorry, Sizemore. Had Fred flash through my head. But we still follow the same type of background check. It's just that the subs are now hired through ESS, and I'm not positive if they pay ESS directly or if they pay us at the time of.
And there's 2 different things. A background check does not cost any money. A local background check through the police department. Fingerprinting is what costs them money. Is that correct, Meredith?
We do it all together, and we don't do a local background check through our police department. We use GCIC, which pulls the totality of everything, and that's all done together. And we use the exact same background check process for our subs that we use for our employees, which is great because we've actually caught things that other districts have missed that proved to be pretty relevant. So I think the background process that our city has is great.
Thank you.
Dr. Gant, did you have a comment?
No.
Okay. My only other comment that I have is there's some details in the policy about, so if we go to the policy, it lists 1, 2, 3 layers of subsequent criminal checks, whereas the reg really only talks about the one every 5 years. Do we want to move all 3 of those into the reg and delete them from the policy? Or Meredith?
Sorry, I'm trying to look back and forth between the 2. I apologize.
So subsequent criminal background checks will be conducted as follows, and then there are 3.
Right, and those 3 are all still true. And then You were asking about that versus what it says in the actual policy itself.
No, those are in the policy. It seems like those ought to be in the reg. But so the reg only talks about every 5 years for continuing employees.
And Mike may have guidance. I don't know that it needs to be in both places, but all three of those are true and they need to be in one place or the other. Mike, which do you feel is more appropriate?
Well, they're a little bit in conflict.
Yeah.
Well, or at least, so the regs just plain says everybody gets one every 5 years and you pay the costs. The policy says, well, that's different for subs because they have to be done every year, not every 5 years. But then the policy doesn't say anything about who pays for it.
They pay for it. All background, well, that's not true. The 5
Subsequent ones, yeah. The regs say that we pay for all the subsequent ones after the initial one. The policy is silent on that.
Okay, personnel. So number 1 addresses the PSC requirement that they have to have their criminal background check when they renew their application. And they can use ours. That actually saves them money because we submit for them on their recertification. The every 5 years, that's automatically done by security. And then substitute teachers and temporary employees are run annually. I would have to verify who pays for the annual on that one. The 5-year one is there's no recharge for that. It's only on the initial, and the same thing with the certification.
So again, it seems like 1, 2, 3 are parts of the reg. And so again, I don't know how much time we really want to spend on this, but like a sentence saying subsequent criminal background checks will be conducted, period, and then have the reg say how and when, or even say, go ahead, Greg,
Yeah,
sorry.
actually, is it possible that we could ask that the reg be folded into the policy? Because that is, nope, no way.
Oh, I don't know. Mike nodded, and so did
Yeah,
Meredith.
I was going to say the same thing. In addition to what Dawn said about the difference in policy and reg, policies general, reg specific, the other difference is usually, policies done by the board and then administration does the regs. If the board's doing it all anyway, I don't see any point in splitting it out. Just roll it. I mean, there's some duplications. There's a little bit of conflict. I'd say roll it into one, like Greg said.
Okay.
So can I propose that and then we can take it up at our next session?
So I think if you propose that, we just delete the reg, because the reg,
But the
well,
reg,
no, because it talks about the payments, the 2 sentences from the reg that are unique would have to get moved into the policy.
but it also has something at the very end of the reg that says the district shall not make blanket prohibitions on employment based on criminal history. And that's really important. In
And
fact,
that's why we reviewed them on a case-by-case basis. That was what I was referring to with that. We can't say just because you've had one felony forever, you can never work for us. We have to on a case.
and I think that needs to be a policy. That needs to be in the policy anyway, in my opinion.
Okay.
Yeah, I would. That's why I'm struggling with all of these, because it's I would agree somewhere that that needs to be a bit more prominent. Because I don't know what, I mean, there's a level of discretion there. So I'm still thinking through what I want to say, but I would agree with Greg on that.
Okay. Well, it sounds like what I'm hearing is go back to policy GAK1 and put back in the part about the costs. Well, maybe not. well, initial costs shall be borne by the applicant, not, and then, so those two sentences that we deleted stay, because they're talking about new faculty or new staff. Sorry, Angela, we're making you go backwards and forwards. And then we go into the reg and grab the edited sentences for fingerprinting. The initial cost will be deducted,
Dr. Yeager, what the policy committee has sometimes done in this situation is said the recommendation is to collapse policy and reg with all pertinent information, bring it to us to be posted for public comment. We'll have another chance to look at it, and we're happy to take on that work. And
Okay, awesome.
I
so
move,
if you move to, right, Mr. Davis, we've done that before. We've
Right,
just said,
right.
this is, you give us your intent, what you would like to have happen. And if you would like these to become one policy and preserve all the language that's relevant, we will do that work.
I think it's better than doing it now, definitely.
All right, awesome. So moved. Dr. Gant, can you give it a second? Are you comfortable with that?
Yeah, I have the questions, but they can wait like until our next meeting about that, about the combining of the regs and stuff. And yeah,
Okay,
but yes, a second.
okay. All in favor? Aye.
Aye.
All right.
And Dr. Gann, I did find out the answer to your question. Even the subs don't pay for the subsequent background check. They still only pay for the first one. All employees only pay for the first one and the costs of the subsequent.
Okay, so that could be one sentence somewhere in the policy. Yeah, okay. All right, the last two are recommended total deletions about staff involvement in decision-making. One is, and they're both kind of complicated gobbledygook about staff involvement in decision-making and redundant with local school governance team language. So again, I think those of you that were on the call at the beginning, I'm a little bit reluctant to just delete whole hog unless we can at the same time that we are doing this point clearly to where we get staff input on decision-making, because I think we have teachers who feel like they are not being listened to, and we don't want to, like, as board, remove all voice from the staff or look like we're removing all voice from the staff. That's my opinion.
I tend to agree with you.
So, Dr. Gant, you missed that conversation that we had while we were waiting for you.
Oh, okay.
But I mean, so we would be deleting these two, well, one policy and one reg, which say very complicated ways of including staff in the decision-making. And Mike's point, I think, is that we have local school governance teams for this. We also talked about the teacher advisory board and maybe some other ways. Meredith talked about how the staff are queried.
Well, and there's also all of the local councils and committees that exist within a school, which this goes into a lot of conversation about, but those aren't necessarily required to have a policy regarding. It's kind of what Mike was saying, the difference in policy and practice. There's, departmental teams that meet where they have a team lead and they have their group meetings and they come together and collaborate on all sorts of things within the school. And then we have TAB, we have LSGTs, we have, the forums where we go to our principal, things of that nature, where we formally solicit teacher input into a lot of processes. And then, of course, they're always free to contact you guys or to contact us directly. And we kind of all try to work that. That was, I think, the conversation that Mike and I had about, this policy is not required to be here. And we didn't know that it was necessarily super current with how the teams are currently formed, and not necessary in that all of those processes exist outside of this policy already. And this policy not being here is not going to eliminate those things.
Okay. I'm also aware of the overreach where we don't really want to tell the district officers how to get teacher feedback, just that we want them to get teacher feedback, right? Is that a fair position from the governance standpoint. So what if we just left the first couple of sentences of the original policy stating our values about getting teacher input? Although the word teacher doesn't actually appear in that sentence, but something along those lines.
I think it might be important to leave it more broad about staff, because you want bus drivers to feel heard about their
Right.
working conditions and how we handle
That's-
discipline on the bus.
Secretaries, right?
Sure, exactly, but so it doesn't even mention the word staff in that first sentence. So should we not add the word staff?
The staff then is more blanket, right? That covers all of our employees.
Yeah. So right now it says shared by the school district, parents, and the community at large. Should we not say staff, parents, and the community at large, or do we want to add staff? Because the district is everybody, I guess, right? Or is it not everybody? Is it just the,
I think.
District is everybody, but do you want to say school district staff for clarification?
okay,
Do you think that might help?
potentially.
With a substitute, they would be considered staff, wouldn't they? Just be temporary staff.
Yeah,
We have temporary staff, and then we have people who work for another company who work in our building. And substitute teachers work for ESS. They're not Clarke County employees. That was part of the board approved that. We have to just kind of distinguish between the two because they aren't our employees, so we can't. Mike can help me here, but you're not really supposed to muddy the line between who your employer is.
Yeah, well, for other purposes, that's right. But I mean, for purposes of this, I think I would assume when they said school district, the intent there was to include board, administration, teachers,
Everybody.
classified, everybody.
okay. So again, I think in the interest of time, I'm okay deleting all of the gobbledygook, especially in the reg, and leaving just that first paragraph, not just the first sentence, but actually the first paragraph is pretty good, I think,
Mhm.
in terms of a policy philosophy discussion about including teams and councils and blah, 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 blah.
So the only decision might be is if you want to start cross-referencing and have policies point to other policies as a charter system with local school governance teams, do you want to reference? I don't have a feeling either way, but BBFA talks about that process. And so in the executive content of your board docs, you can see that we put the BBFA language.
Right.
We could just put something in GAC that says, as a charter district, there's this process called local school governance teams, which is inclusive of school staff input, period.
Right, right.
And that would allow someone to reference.
Right, right. And BBFA, though, doesn't actually use the word staff, which seemed odd to me. Am I missing something? Talks about parents and community members.
I don't know the B policies, but I know that we've got teachers on every LSGT.
Yeah.
I don't know the details, kind of out of my scope on that one.
Yeah, for sure. No, I agree with you that they're on the teams, but I just think, we don't want to reference this policy only and not mention that there's staff involved. So, so again, okay, in the interest of time.
I don't want
Go
to
ahead.
single out one policy, because yeah, I agree. What's wrong with just leaving that first paragraph as is?
I
Without,
think we can just leave it. Yeah,
Well, and it'll go to the full board, right, for more discussion.
right.
right.
But then we're comfortable deleting the reg, obviously. Okay.
Yes.
All right. Do we have a motion? Move this forward?
So moved.
Second.
All in favor?
Aye.
Aye.
Okay,
Sorry, I missed, did you want a sentence added to reference the LSGT policy or no? No, just leave it as is. I think aspirational is fine as well.
okay. I think the LSGT falls underneath that broad paragraph.
Okay,
It's what we're doing right now, but it may not be what we're doing 5 years from now. So maybe
That's
just
right.
leave it alone.
okey doke.
Okay,
Right.
so is there any further business?
Woo.
Do I have a motion to adjourn?
Motion.
Second.
Okay, all in favor?
Aye.
Aye.
Aye. All right, we'll see you in a few minutes.
Okay.
Three.
Thanks, everybody. Whew.
Thanks.